Good evening. I'm Leslie Weir, the University Librarian from the University of Ottawa, and I'm here representing the Ontario Council of University Libraries. We represent the 21 universities in Ontario, and we serve approximately 500,000 faculty, student, and researchers here in the province. OCL is very encouraged by the attention that the government is bringing to the challenging task of enabling Canadian copyright legislation for the 21st century. We feel that a fair balance must be struck in any new copyright legislation between the copyright holders and their right for fair compensation and the public good. University libraries depend on the concept of fair dealing and other exceptions in the Copyright Act in order to serve the students and researchers who depend upon access to and use of copyright materials for the learning, discovery, and innovation that benefits all of our society. Fair dealing, we have the unanimous Supreme Court decision of CCH in 2004 that identified fair dealing as a right that must be interpreted broadly. The ability of users of copyright materials to exercise their fair dealing must not be compromised in any new legislation. There are two important ways that the enjoyment of fair dealing could be compromised: through digital locks, also called technological measures, and through the threat of statutory damages. For digital locks, they can prevent users from interacting with copyright materials in ways that are perfectly legal. Copyright law must not make it illegal to circumvent a digital lock in order to use a copyrighted material for use that does not infringe copyright. WIPO treaty obligations. In WIPO treaty obligations, it's sufficient that copyright law afford protection to digital locks only to penalize breaking of digital locks for infringing purposes. Libraries should also be able to migrate materials to new formats when we are approaching obsolescence. If we actually wait for obsolescence to happen, then we won't have the equipment to be able to read, access, and migrate the materials that are a threat of loss. We would also like to suggest that to be able to serve Canadians with disabilities, it's extremely important to be able to provide access in formats that support their needs. Finally, we'd like to say that damages, where there is statutory damages, are a chilling effect on the enjoyment of the user rights. And so we would like to suggest that, in fact, it would be more appropriate for people to be liable to just straight damages if they are not purposely trying to infringe on copyright. Thank you very much.
Thank you. That was speaker number 2. If speaker 136 does not wish to speak, we will go to the web. All right, Nicole?
Okay. So Craig from Toronto, I think there's a simple question here. What are the rights of Canadian citizens? In Canada, we don't even have the kind of fair use protection for criticism, parody, and research that our American friends take for granted. So why should we endure the erosion of what little rights Canadian citizens already have and the demolition of the public domain to go along with it? Yes, Canadians value their artists and value their works tremendously, but they also value the rights that they're entitled to as Canadian citizens. And they don't want to see their grandmothers and teenagers sued into poverty or sent to jail in order to protect the industry's business models. There's another comment from Charlotte. The nonprofit, volunteer-based campus and community radio sector is one place where you can hear emerging artists on the airwaves. But with the multiplication of tariffs from different copyright collectives and different uses, for example, radio, streaming, podcasting, archiving, these nonprofit stations are having problems paying to broadcast these artists using new technologies. The sector is trying to give exposure to emerging artists and doesn't have the revenue available to pay as much to tariffs as big commercial broadcasters. It's harder to sell ads on a station playing smaller and unknown artists. But they can't keep up with all the tariffs. Some sort of caps are needed. In this case, the copyright tariff system is then not helping emerging artists get the exposure they need to become more successful and get the royalties they deserve.
Thank you. Number 14. Pass. No, there we are. Thank you. Number 137 and 12, if you'd like to go to the microphone.
All right. Hi, my name's Paul Vett. I'm a software developer. I'm just going to be really brief here. basically, like, I think a lot of people are painting this debate as a debate between two extremes, and really, it's not that everybody wants to either abolish copyright or have infinite copyright. I think we're all looking for a spot in the middle. So it would be nice to kind of drop some of the rhetoric and focus on the nuances, because it's quite complicated, and there are a number of issues that I think are important and sort of guidelines that I think we should go from. And first of all, I think we need to not legislate TPMs at all. We need to totally not put them in the laws. I mean, industry is already abandoning TPMs. They simply do not work, and there's no reason to protect them. The Americans have shown us that TPMs will have all sorts of consequences that we can't anticipate. Garage door opener companies suing each other, things like that. And what's the benefit? There is none. And I say that as a software developer. I develop software for BlackBerries, and so copyright affects me. But I don't think we should be enshrining TPMs in law. It's just too risky. Second of all, I'd like to support notice and notice rather than notice and takedown. I don't think that's really being debated too much here. And so what I was saying at the start was it's not two extremes. We need to recognize that everybody is a creator in Canada now, right? I mean, I've been tweeting as this goes along. That stuff is all copyright me. And people who have been reading it are my, I guess, consumers. And likewise, even people in more like industries like music, where like, say, a rock musician. A rock musician, I mean, ultimately is building on blues music, right? And blues musicians ultimately built on each other. And so to say that they're strictly creators, I think, is misleading, because they're actually consumers of the music that came before them. I forget the artist, but an old blues artist told a story. He had 3 different stories for how he wrote a particular song. One is that he heard someone else play it. One is that he remembers composing it himself while working on his car. And so you can't simplify the act of creation. It builds on previous creation. And finally, I think we need to simplify copyright laws. It's terribly confusing, right? And as I mentioned, everybody is now involved. Everybody is copying, everybody is creating, and having complex laws doesn't help, right? Do I know if a particular act is infringing? I don't. I tried to make a parody video during the last election, and I wasn't sure if it was legal because I was going to use clips from Seinfeld. Is that legal in Canada? Probably not. And do we really want to stifle political speech? I don't think so. And finally, I'd like to say no to retroactive term extensions or even future-looking term extensions. You can't encourage dead artists to create more works. Thank you.
All right. 137. We have. Go ahead. Go ahead, number 12. We'll get 137 up.
Hi, my name is Rob Bolton, and I work at Warner Music Canada, and I'll be brief because some of the comments made earlier I agree with completely about the right of choice of artists. I've worked in all aspects of the music industry, I should point out, both with artists as a journalist. I've also worked in technology startups as well, so companies that actually fought the record labels to bring new digital innovations to Canada, and I can say that what we have in this country is truly a lawless society, and it's very difficult to build legitimate businesses here. And you'll hear a lot of people say, and advocates of peer-to-peer technology, that this creates this utopia of sampling, and you can discover artists and people will spend more money on music. That simply isn't true. While yes, I get that, I understand that if you can sample music, you'll buy more music, but it exists. You can go to an artist's website, you can play songs there, you can go to their MySpace page and sample songs. We truly live in a utopia of music fans being able to sample music anywhere legitimately on artist-chosen websites. And then if you like it, you can buy it. What peer-to-peer does is it removes that choice. I was listening to the Montreal Town Hall, and I thought it was quite funny. Someone gave the rather ludicrous example or a metaphor of, well, if I come into his house and steal his TV, that's theft. But if I take a track from his computer via peer-to-peer, it's not theft because he still has that track. He is not inconvenienced in any way. Well, that's true. That person is not inconvenienced. It's not theft from them, but it is theft from the artist who created that music. They are expecting compensation in exchange for that piece of music, and that was taken away from them. That choice was taken away by the use of peer-to-peer. All we're asking is that choice is given to the artist. Yes, the point was made earlier. Some artists choose to give away their music for free. That's great. Plenty of in fact, almost every artist now gives away 1 or 2 tracks as a free MP3 as a way of sampling, usually streaming many more on their website. It truly is amazing how much you can sample now, and you don't need to take it from that artist. And all they ask is to be compensated in exchange for that. Basically getting music for free on the internet, it's the choice of the artist if they want to make it. It is not the consumer's privilege, and it is certainly not their right. Thank you.
All right.